code Defaulters Paradise Lost. We have in our midst today our chief guest, Honorable Justice Sri Sanjeev Khanna, the Honorable Judge of the Supreme Court of India, the guest of honor, Honorable Justice Sri Ashok Bhushan, the Chairperson of the NCLAT, and the special guest, Honorable Justice Sri Ramalingam Sudhakar, the President of the NCLT. I request your Lordships to please come on the dais. I would also request Sri Raghav Chandra, our moderator for the day, to please join us on the dais. Thank you. I would request the dignitaries to please unveil the book now.
Come, Anant, you must also come. To get this window, something sharp.
I now hand over to Sri Raghav Chandra, retired IAS officer, author, adjunct faculty of the Indian Institute of Corporate Affairs, today's moderator, to kindly take the session forward. Sir.
Honorable judges on the dais, distinguished members of the bar and bench, distinguished ladies and gentlemen, I have great pleasure in welcoming you to the launch of Anant Mirathia's book, Defaulters Paradise Lost, Demystifying the Bankruptcy and Insolvency Code. Our chief guest today is Justice Sanjeev Khanna, Judge of the Supreme Court of India, and we have two guests of honor, Justice Ashok Bhushan, Chairman of the National Company Law Appellate Tribunal, the NCLAT, and Justice Ramalingam Sudhakar, President of the National Company Law Tribunal, the NCLT. As you would agree, this body of legal luminaries is, as to use a legal word, apposite as it gets to authenticate, validate, and bless a book on such a crucial subject. Justice Sanjeev Khanna was elevated as Judge of the Supreme Court of India in January 2019 after he served as a judge at the Delhi High Court for 13 years. He is the third senior judge presently at the Supreme Court of India. Some of the notable judgments contributions of his include the Central Public Information Officer, Supreme Court of India versus Subhash Chandra Agarwal judgment, popularly known as the RTI judgment, wherein he authored the majority opinion of the 5-judge bench and held that the need for judicial independence does not stand in contradiction with that for transparency. The seminal judgment in the case of Amish Devgan versus Union of India and others in the field of freedom of speech and expression under Article 19(1)(a) of the Constitution of India explained the contours of hate speech. Union of India and others versus Agricas LLP and others, etc., is a leading case pertaining to India's foreign trade and imports-exports, wherein he has interpreted sections 3 and 9(a) of the Foreign Trade Development and Regulation Act of 1992 and the GATT, the General Agreement on Tariffs and Trade, 1994 obligations to clarify the scope of the powers of the central government in imposing quantitative restrictions on trade. His judgment in Vidya Drolia and others versus Durga Trading Corporation and others puts forth a 4-fold test to determine arbitrability of subject matter of a dispute. Further, in the case of PTC India Financial Services Limited versus Venkateshwarallu, Kari and others, the long-standing debate on the law of pledge and the special rights contemplated for the pledgee with reference to pledge of dematerialized securities was critically analyzed and elucidated. Recently, in the matter of Shilpa Shailesh versus Varun Srinivasan, a Constitution Bench judgment authored by Justice Khanna, the contours of the Supreme Court's powers under Article 142 of the Constitution of India were examined, specifically with reference to the law of divorce in India. And even today, I was pleasantly surprised when I came in to look at the Economic Times and to see that there was a reference. The Supreme Court refuses to restrain NCLT from undertaking insolvency proceedings in the RCAP case. So he's absolutely on the ball on this subject. Justice Ashok Bhushan is the chairperson of the National Company Law Appellate Tribunal and a retired judge of the Supreme Court of India. Some of the notable contributions made by Justice Ashok Bhushan include his concurring judgment in Justice K.S. Puttaswamy versus Union of India, upholding the constitutional validity of the Aadhaar, that is the Targeted Delivery of Financial and Other Subsidies, Benefits and Services Act of 2016. In the Union Bank of India versus Dinkar T. Venkata Subramaniam, he has authored the majority opinion of the 5-judge bench, wherein it was held NCLT has the inherent authority under Rule 11 of the NCLAT Rules 2016 to recall its decision if there is sufficient grounds and when a procedural error was made during the delivery of the earlier decision. Justice Ramalingam Sudhakar is the President, National Company Law Tribunal, the NCLT. He has rendered landmark judgments in all branches of law like original side appeals, tax cases, arbitration cases, admiralty cases, and so on. But his passion for environmental conservation stands out, and that has led to the restoration of the Shola forest of the Western Ghats, the removal of prosperous Juliflora, the invasive shrub which is destroying the ecology of various parts of the country. His judgment in motor accident cases directing the payment of compensation directly to the beneficiaries has been applied across the country now. He was responsible for establishment of the Arbitration Center of the Madras High Court. His extensive judicial experience and administrative capabilities have helped steer the NCLT benches of India into an effective resolution mechanism with a 36% recovery, the highest so far, besides increase in resolution plans. And coming to our author, young Anant Mirathia, he is a practicing corporate litigation and disputes resolution lawyer and heads Anant Marathia and Associates, a legal practice firm in Chennai. He holds formal overseas legal qualifications and has several years of experience both in India and Singapore. Ananth focuses on corporate, commercial litigation and arbitrations, apart from advising businesses on corporate restructuring and handling shareholder disputes. He also advises clients on cross-border transactions and litigations. He has formulated his thoughts and practical knowledge over the years on the topic of Insolvency and Bankruptcy Code 2016 into his first book by accumulating data and resources over a period of 3 years to provide his valuable insights in a simplified manner in this dynamic area of law. Ladies and gentlemen, just to mention that after the inaugural session, we have a very vibrant lineup of other legal luminaries as well to further debate various aspects of this subject in a more nuanced manner. This will include Shri Arun Kathpalia, Senior Advocate, Supreme Court of India, Shri Rana Mukherjee, Senior Advocate, Supreme Court of India, Messrs. Madhvi Goradia Diwan, Senior Advocate, Supreme Court of India, and Shri Sumant Batra, Insolvency Lawyer. Coming to the book and the subject of today's deliberations, I remember almost 2 decades ago as a young managing director of the Madhya Pradesh Industrial Development Corporation in the period between 2004 and 2006, and this is, I'm talking of 2004, I had a group of visiting financial analysts and CEOs of investment firms, including Goldman Sachs, and I remarked over dinner across the table that India was a great place to live in because of the various comforts that we have in terms of servants and amenities, but perhaps not yet a good place to do business in, and I was rather apologetic. I remember that they chuckled and responded, on the contrary, India is perhaps not yet a good place to live in, but a great place to do business in for a businessman because Indian laws are lax, easy, and they can be defeated at any given time. And I soon realized that this was indeed true. MPSIDC had in the past extended large loans to businessmen who feigned an interest in setting up industries, calling them intercorporate deposits. Many of them refused to repay the loan. Recovering these loans from defaulting businessmen was a nightmare. We went to DRT, DIFR, AIFR, pursued action under the SARFAESI Act, but it was all child's play against hardened defaulters. And even today, a fraction of that original amount has been recovered because all the businessmen continued to be at the helm of their companies, even though they declared themselves sick. They continued to milk the finances as per their own volition, and they were able to persuade and renegotiate with a helpless state to agree at a one-time settlement of the principal at a hefty discount while waiving off the interest component completely. A decade later, in late 2015 and December 2015 to be precise, one particular social gathering in India made national and global headlines. It was Vijay Mallya's 3-day party to mark his 60th birthday, which had the famous Spanish pop star Enrique Iglesias being present to entertain the guests. The Economist magazine commented, and I'm quoting from The Economist, "Mr. Mallya is hardly the only embattled Indian tycoon to have cocked a snook at his bankers. Some promoters of companies as founding shareholders of Indian companies are known, have long made full use of a loophole of local corporate law that thwarted banks' attempt to seize companies in default of their loans. A bunged-up court system made foreclosure all but impossible, so owners of even the sickliest of companies could spend lavishly without fear of repercussions." Even though Mr. Mallya and several others like him, including many of the defaulters of the erstwhile MPSIDC, have fled abroad, that party is now over. A new era has dawned, and as very aptly observed by Justice Rohanthan Nariman in the Swiss Ribbons versus Union of India case, quoting from John Milton's epic poem about Adam and Eve who fall prey to temptation and are banished from the Garden of Eden, the defaulter's paradise is lost. In its place, the economy's rightful place has been regained. The Insolvency and Bankruptcy Code enacted in May 2016 is a comprehensive and holistic law meant to consolidate and rationalize the earlier laws relating to reorganization and insolvency resolution of corporate entities in a time-bound manner so as to maximize the value of assets of such persons, to promote entrepreneurship, availability of credit and balance the interests of all the stakeholders, including the government, by the initiating of corporate insolvency proceedings and the preparation of a resolution plan. This law has ushered in a new era in corporate governance. Its impact has been noteworthy. It has helped banks get rid of their high NPAs that had been the bane of the Indian banking system. Earlier, bank officials, I remember, feared taking decisions on bad loans because they said that that would land them into the lap of the CBI because of audit objections. It has helped banks increase their level of credit to companies, and that's one of the reasons why our economy is doing much better today. Encouraged companies to go in for better corporate governance and to monitor their finances better. As an independent director on various company boards, I see how seriously meetings of the audit committee are taken today. It has improved the stock prices of better managed companies, helped zombie companies to come into the corporate asylum of better managed companies, and instilled fear in the minds of those who took corporate governance lightly, and most importantly, it has led to a shift in the power balance between creditors and debtors. Anant Mirathia's book has been inspired by Justice Nariman's quote that I just mentioned, and it dwells in detail on various aspects of this law. It offers a practical perspective to the different stakeholders involved in insolvency and liquidation proceedings. This practical and thought-provoking book has won lots of plaudits from legal practitioners and in India and abroad, and some of his from Singapore and so on are here. Justice Senthil Ramamurthy of the Madras High Court has summed it up very well when he says, "The author neither oversimplifies nor intimidates, but accomplishes this arduous task of illuminating a complex subject at the intersection of law, governance, and commerce." But it is best to hear from the horse's mouth, and so I now request Shri Anant Marathia to tell us more about his outstanding book.
Honorable Justice Shri Sanjeev Khanna, Honorable Justice Shri Ashok Bhushan, Honorable Justice Shri Ramalingam Sudhakar, the Honorable Members of the NCLAT and the NCLT, distinguished panelists, Moderator Shri Raghav Chandra, distinguished guests, ladies and gentlemen. It gives me immense pleasure to stand before you as the author of Defaulters Paradise Lost, Demystifying the Insolvency and Bankruptcy Code 2016. IBC, as we all know, is one of the unique legislations in the country which has brought together in the same sphere of discussion varied subjects such as business, economy, finance, commerce, law, and possibly a lot more. This is a legislation that has had an impact on the widest range of stakeholders. To break this down a little further, IBC impacts businesses that operate as trade creditors, manufacturers, suppliers, consumers, service providers, bankers, financial institutions, entrepreneurs, personal guarantors, workmen and employees, government departments, insolvency professionals, as the officers of the court, so on and so forth. When we started working on this project of this book in 2019, the primary objective that we had in mind is that when a law touches upon the lives of so many stakeholders, should there not be a book which can be a go-to guide or a reference guide for all of them? Moreover, when the intent and design of the law itself is to have a wider inclusion of stakeholders in the process compared to the earlier regimes being the winding up of companies or the one under BIFR, we were very clear as a team working on the book that this book, when completed, should be a simple, accessible guide, not just for the professionals associated with IBC, but also for the stakeholders impacted by it. To cite a couple of examples, not every bank official would be well versed with the insolvency code, but will have to deal with situations connected to the code at different points of time in their professional obligations. Similarly, not every finance and legal in-house professional would know the subject very well, but would be faced with situations wherein they need to take a decision and they need a clear understanding of the basics of at least the procedural part of the law and the substantive part of the law. As the management of the company with which these professionals are associated, they would entrust the responsibility of handling the situation to these professionals, and certainly these are both high pressure and time bound. It dawned on us that it is not practically possible for every professional to be fully aware of the law to this extent, which is both dynamic, rapidly evolving, and hence, as a fellow professional, I felt I should endeavor along with my team to provide a book that captures the journey of IBC right since its inception till the time that we have written this book, and focus on issues in a stakeholder-wise manner. We believe that this book is a must-have for the offices of small and medium businesses, of course corporates definitely, financial institutions and the NBFCs, universities, both law and business management universities, libraries of chartered accountants, company secretaries, finance and insolvency professionals, and even foreign lawyers who may need to familiarize themselves with the insolvency code in one context or the other. I say this with all humility that this book would be a great read for anyone trying to understand the corporate insolvency landscape in India at the very ground level. Moreover, we are confident that this book will be of great assistance to professionals dealing with corporate insolvency matters day in and day out. Finally, I'd like to say that Defaulters Paradise Lost is not just a book, but it is a progressive initiative from our side to empower all the concerned stakeholders impacted by this dynamic yet complex legislation. Thank you so much.
I'll now request Justice Ramalingam Sudhakar, the President of the National Company Law Tribunal, to deliver his address.
Respected my Lord Justice Sanjeev Khanna of the Honorable Supreme Court, Honorable Justice Ashok Bhushan, Chairperson of the National Company Law Appellate Tribunal, the Mr. Raghavendra who is now guiding us through this program, and Anand Merathia, the author of the wonderful book. When I started my career as a judge, Madras High Court is a chartered high court, as you all know. One of the primary issues which deal with insolvency court, if you are a judge of the original site, and I was, all I had to do was to clean up the insolvency and bankruptcy cases. Clean up, I mean, which has been pending for 20, 30 long years, and I did so. Just cleaning up. We have to wash off everything which is on the table, and some of the cases I can quote is Anubhav Plantations, some of companies like old cinema companies. Huge amounts got wasted in the process, but nothing concrete came. So demystifying the code happened in 2016. The insolvency procedure got demystified and something new came as a law. As we all know that the earlier laws like SARFAESI, DRT, BIFR did not work. Innumerable judgments have been given by judges across the country on these laws interpreting the provisions of the statute. But as a judge, I realized the more litigation came from the defaulters trying to find some way or other to get over the payment of the debt. It has always been their paradise to seek the court of law and not pay the money. In the bargain, the debtors enjoyed greater benefit, creditors were nowhere in the picture, workmen suffered, economy also suffered. In 1990s, the government of India wanted to open up the trade and commerce because of World Bank and WHO organizations. So a marked change came in the system, and then we had adopted something called global economy concepts, where trade had to be harmonized with the international parlance. Along with it came so many requirement of compliances by the government of India, which included ease of doing business. It did not happen well. We were down the line. So, thanks to the government and the framers of the laws, they came out with this code in 2016. Now I am having the benefit of seeing the code as a president of NCLT along with my brother members. One thing I realized, what was once a shrouded and clouded insolvency proceedings is now become very vibrant. If you look at the code, it started with a lot of troubles, as with all other cases, as I said before. But fortunately, we had able guidance from the Honorable NCLAT and from the Honorable Supreme Court, time and again giving their able guidance as to how to resolve cases and go forward. But for the Honorable Supreme Court and the NCLAT's guidance, we could not be here in this stature. I tell you what is that stature. Barring few lapses during the COVID times, we now have an enormous result, appreciable, and also which is of matter for reckoning. In the last year, IBB has given a report of 180 plans approved, and the figures are so enormous. The Section 7, 9 and 10, which is the core of the IBC, we have so far from 17 to 2023, 33,300 cases. Number of cases pending pre-admission is about 5,000. Number of cases pending after admission is about 3,800. Number of cases disposed of is 25,849. And number of cases adjudicated is 29,703. The percentage is almost 86% for Section 7, 90% for Section 9, and 95% for Section 10. In terms of plan approved amount is 3,49,000 crores over this period of time. The cases also get settled because of the proactive nature taken by the NCLT, which is almost around 409 cases. Withdrawal after 12A is about 850 cases. And the total resolution plan, what I said 180 was for the last year, but total is 730 plans approved so far of 3,49,685 crores. These figures maybe was mined by us because we were faced with a situation where there was a misconception in the public mind that NCLT is not giving up to the timeline, it was not performing well, and something was radically wrong with the NCLT, and we started re-looking into our data, thanks to my brothers here, and that data showed that our performance was really good, much better than what the earlier laws like DRT, SURFACE or BFR had achieved. It's about 36% from my BBA's report. Having said that, we have regular colloquiums where we understand and try to demystify the code to improve and enhance our capabilities. With that came something very interesting. The IIM Ahmedabad gave a report which is of, I think it's August 23. Besides this recovery data which we have, this is what the IIM's report based on our data which is shared by IBBI. The Insolvency and Bankruptcy Code has remarkably altered how distressed and defaulting businesses are handled by the stakeholders. The creditors have on an average realized 32% of the admitted claims, 168% of the liquidation value in cases resolved under IBC. The data primarily reflects the outcome in terms of financial recovery. However, it is essential to recognize that the success of resolution goes beyond those recovery figures. Now, 7 years have passed since the implementation of the legislation, and according to this report, the report compares the performance of resolved firms against their peers by sector and size. This comparison tells the magnitude of the gap and separates the change that have arisen due to market forces. Some of the key findings are: average sales have shown an increase of 76% in the 3 years since resolution. The 50% increase in average employee expenses in the 3 years post-resolution, indicating higher employment intensity in the resolved firms post-resolution period. The trend indicates significant increase, about 50% in the average total assets of resolved firms post-resolution. This is coupled with 130% increase in the capex, which indicates the buildup of tangible assets in the balance sheet of these firms post-resolution period. The report finds that there is a convergence in the profitability ratio of the resolved firms with the benchmark averages in the post-resolution period. The trends in the market capitalization of listed resolved firms indicate a significant revival in the average market valuation in the post-resolution period. The liquidity has improved in post-resolution period about 80%. The trends indicate significant increase in the liquidity of resolved firms in the post-resolution period. These are some of the findings of the report by IIM Ahmedabad, which has been given to us on the basis of a request from IBBI. Having said this, there is an overall improvement in the corporate governance in the country because of this new code. Now, should we say that there is a feather in our cap and enjoy what we have had today? I said no, it's not. My analysis and thought is on these lines. I find that many banks over the last 2 decades have been funding debtors who are now before us or before the earlier regime without proper due diligence. There is absolutely no way we can say that banks have been, throwing their money against people who obviously they know that they are not going to come back and pay, as our Mr. Raghavendra was saying about 1 or 2 incidents. So the issue should start from the bank. The code is one which we do at the end of the show. But before the show starts, the bank should be diligent and vigilant. Number 2, the stakeholders or the people in the part of governance and the corporates, there has to be some method where the default at the first instance comes to the what is called red flag or orange flag, and before the erosion of the value comes, it has to be taken into the CRP process. That speed, we have that, but unfortunately the banks are coming at a moment when it is past the ICU stage. They should do it at the earliest point of time because that saves. I think with this new code, India seems to be on a much better footing as against other countries in the world insofar as insolvency resolution, but that data needs to be collated. The next part, which I now realize after the IIM report, is that this code has enabled the benefit not only to the resolved company, to the workman, to the industry and to the creditors, because I was told that 1 rupee goes back into the system is enabling 10 rupees back into the system. So which means so many thousand crores that has gone back through the orders of NCLT or the process by IBC is a tenfold gain to the economy of this country. Now, why do I say all this record? Because our friend Marathia has given this book called Defaulter's Paradise. The book is very nice and simple to read, really worth for people who want to see how to demystify the code, which I said earlier. So I congratulate him on that. But when the defaulters lost the paradise, the IBC regained that paradise for the economy of this country. So that is how the code operates. It is no more a paradise for defaulter, but it's a paradise for the economy. And with that, I thank all of you.
Thank you, Justice Ramalingam Sudhakar, for a very, very illuminating address, telling us all about the innumerable successes of the NCLT, which has indeed done yeoman's work, the need for safeguards and vigilance by banks and lenders, and the overall benefits to the Indian economy. I now request Justice Ashok Bhushan, the chairperson of the National Company Law Appellate Tribunal and retired judge of the Supreme Court, to deliver his address.
Thank you, Mr. Chandra. Justice Sanjeev Khanna, Judge, Supreme Court of India. My brother Sudhakar, Ramalingam Sudhakar. Sri Anant Marathia, in whose honor this function is being held. Mr. Raghav Chandra, former IAS, who is conducting the function. Mr. Alok Srivastava, member of the NCLAT, other members of NCLT, Mr. Viren Ganda, President of the NCLT Bar, senior advocates, members of the bar, ladies and gentlemen. We have gathered here today on the occasion of release of Mr. Anant Marathia's book entitled Defaulter's Paradise Lost, Demystifying the Insolvency and Bankruptcy Code 2016. I am glad that Mr. Marathia has been able to bring together his vast knowledge and expertise in the area of insolvency law in the form of this gem of book. The book lucidly explains the intricacies of the insolvency liquidation regime while also covering the process and procedures for insolvency for personal guarantors as well as pre-pack insolvency regime in India. There are 15 chapters in the book, and all these chapters are perfectly drafted, keeping in mind the different levels of awareness of its readers. Each chapter of the book is independent of others and complete in itself, starting with explaining how and why the code came into existence to navigating the readers through the important topics in the code. The book is valuable not only for the legal professionals but also for other participants and stakeholders involved with the process of insolvency like creditors, resolution professionals, liquidators, finance professionals, chartered accountants and company secretaries. The book is especially helpful to small and medium-sized companies who generally lack easy availability to expert professional advice on insolvency-related matters. Looking in details at how the various chapters of the book have been curated, I would like to share with you my take on this book. To begin with, if we look at the flow of the contents of this book, we begin by finding a wholesome commentary on the various dimensions of the IBC, starting from the evolutionary history behind the code to the discussion on its impact on the economy, where on one hand the author has elucidated on the IBC's theoretical framework in detail for the benefit of the insolvency practitioners and scholars. He has been effective in discussing the practical problems associated with the implementation of the IBC. Moving further, the author has separately dwelt on the issues faced by the various participants in the insolvency mechanism. Further, the author has highlighted the difference between the process and implications of resolution vis-a-vis that of liquidation. The book also touches upon the facets of pre-pack insolvency process as also with the perceived future of the Indian insolvency regime. The intent behind the law and its impact are wisely established by the author as we ventures deeper in the book. A bird's eye view of the code and the statute's effect on the MSME sector are discussed next. The book then moves on to discuss the insolvency law regimes of some of the top developed countries of the world. It gives a statistical glimpse at the current scenario in India, accompanied with the challenge of the sector in India. Mr. Marathia has done justice to explaining how the IBC, being such a new law, has seen so many legislative interceptions in the form of ordinances and amendments in just so few years since its inception. IBC is quite a dynamic law, with the frequent amendments being introduced in it by the legislature, and with the variety of valuable judicial pronouncements and interpretation, we can see in real time, as demonstrated in the book, how the legislative intent of revival of distressed companies and the idea of maximizing resolution behind coming up with the code is being actively put into practice. This book by Mr. Marathia is a valuable reference guide on insolvency law and practice in India and can predictably be an excellent scholarly resource for different parties participating in the insolvency resolution mechanism. It successfully iterates the different roles, responsibilities, rights and interplay of the different stakeholders and parties to the corporate insolvency resolution process. Talking about the framework of the code, the author has elaborated upon the jurisdiction of the powers and mandate of the adjudicating authority, appellate tribunal and the higher judiciary when deciding over issues arising out of the CIRP. Further, the threshold trigger for initiating CIRP, applicable of Limitation Act 1963 and timeline for resolution related processes. Moreover, the roles of the some of the pillars of the IBC, that is IPs, insolvency professional entities, insolvency professional agencies and the regulator, Insolvency and Bankruptcy Board of India. The author has also done a splendid work when he gives out practical tips to businesses, thus distilling his learning into actionable guidance. The next part of the book deals with identifying the key stakeholders to the insolvency process and the various issues affecting them. Stakeholders like the corporate debtor, different types of creditors, promoters, employees, guarantors, insolvency professionals, home buyers and resolution applicants have been identified and their roles and challenges are discussed therein. Taking help of statistical data and important judicial pronouncement, the author succeeds in weaving a clear and detailed informative piece on the roles, responsibilities and concerns of these stakeholders under the IBC. Coming to the chapter on practical issues faced in filing procedures, the author has wisely included different possible scenarios which may occur at the time of filing a CIRP application by the various types of applicants. The author deals with features like who is to bear the costs borne out of the initiating a CIRP. This is one such area where ordinarily the creditors do not have much idea and is therefore quite informative. The author then proceeds to discuss the procedures for out-of-court settlements, rejection of application, admission of applications, appeal mechanism, withdrawal of the IBC application by the creditors, and the challenges involved with the same. Next, the author deals with the position of different types of creditors under the code extensively, the issue of getting a place in the COC, voting rights, acceptance of workers and employees in the category of operational creditors, and home buyers as financial creditors, challenges of unsecured creditors, etc. are some examples of the intriguing discussions ventured into by the author. One of the key features of the book is that to explain his point better to his readers, the author has cited many important Supreme Court and ANCLAT judgments. Another important feature of the book is that there are entire chapters dedicated to the issues affecting the various parties and stakeholders to the CIRP other than the creditors, like the corporate debtor, promoters, insolvency professionals, and resolution applicants, all of them being participants of CIRP whose perspective and challenges are often overshadowed in the average insolvency resolution related commentaries and discussion. To give an example, the author, by using pronouncements and statistical data, discusses the role of promoters both before and after CIRP. The book also does justice to discussing ordinarily peripheral concepts like avoidable transaction, plight of personal guarantors, and statutory and criminal liabilities with respect to section 32 A of the IBC. Further, the author provides the answer to the question of who shall bear the expenses of resolution professional on initiating CIRP, while also throwing light upon the silent tussle between the interest, motivations, and duties of the COC, RP, and the adjudicating authority respectively. Moreover, the book also ventures into explaining how different FCs who form the COC may be differentiated on the basis of holding security charge, resulting in classification of FC as either secured or unsecured type. Also, the transitional challenges arising from handover of duties from RP to liquidator are elaborated upon in the book as well. One of my favorite chapters in the book is chapter 10, which deals with resolution applicants. This part includes the eligibility criteria laid down for a resolution applicant, the leeway given to MSMEs, and the impact of asset reconstruction companies being resolution applicants. The sheer amount of details, breadth of study, use of cases scenario and case examples supported by theory and data by the author to explain his knowledge and understanding of the topic is an exemplary specimen of topic well dealt with. The book is meant for experts as well as new beginners. An apt example for this is chapter 11 of the book, explaining the difference between the resolution versus liquidation mechanism. The author reasons how liquidation is detrimental to the interest of financial creditors and other stakeholders, while resolution offers the ideal solution. The author lists the essential ingredients of an eligible resolution plan to give his readers an idea of what to expect from a resolution. Moving over to explain the rule of majority in decision making, the COC, the author stresses over the importance of the commercial wisdom of the COC along with a need for minimum judicial intervention in such decision. Beside the multitude of subtopics dealt with by the author under this part, the more important ones that I would like to mention here are a discussion on timeline that need to be adhered to under these two mechanisms. The waterfall mechanism under liquidation mechanism as per section 53 of the code, and key differences between the role of resolution professional versus that of liquidator. Chapter 12 of the book that deals with pre-pack insolvency differentiate effectively between CIRP and pre-packed insolvency resolution process, starting with the need for having the pre-pack in India in the first place. The author moves on to enlist the requirements under the process, duties of resolution professionals, to discussing the timelines, to the expectation from the management of the corporate debtor, illuminating the difference between a regular CIRP and pre-pack, The author proceeds by discussing the role of COC during pre-pack, the contents and approval of the resolution plan, closure of the process, and avoidance applications in the context of pre-pack. In the context of the given topic, the author has also discussed the significance of the Swiss challenge method in ensuring value maximization. The author has discussed insolvency and bankruptcy process relating to personal guarantors, which has been one of the most recent provisions of the IBC that have been notified on 15th November 2019 and brought into effect. Since this particular part within the code is at its nascent state of evolution and implementation, the author has done a commendable job explaining the particulars of such an insolvency process, including details of who can apply, effect of moratorium, repayment plan, and meeting of creditors. Having explained the insolvency part, the author moves on to explain the process of bankruptcy using case examples, whereby he deals with the procedure under bankruptcy, details of meeting of creditors, administration of a distribution of estates of bankrupt. Further on, he explains waterfall mechanism for priority of payment, discharge, and disqualification of bankrupt avoidance transaction. In the final chapter, the author discusses what the visualize as the future path of the code. In this chapter, the author talks on areas that he feels are currently in need of more clarity. For example, the continuation of proceeding for avoidable transaction and improper trading of the after CIRP, and change in threshold date for look back period, minor topics like curbing submissions of unsolicited resolution plans and revisions of resolution plan, timeline for approval or rejection of resolution plan. Some salient points of this book is that it is easy to comprehend because of its simple language and approach. It is divided in independent chapters dealing with a specific topic, thus making it a quick guide on these topics. The author has been successful in sticking a balance in supporting his theoretical explanation with practical example, thereby going beyond being a mere commentary on Indian insolvency law. I would like to conclude this speech by extending my sincere gratitude to everyone present here and congratulate Mr. Marathia and his team on having coming up with this excellent book and organizing this book launch successfully. I extend them my best wishes in the success of this book. I am sure this book shall be grand success and that its readers are going to be hugely benefited from it. Thank you. Jai Hind.
Thank you, Justice Ashok Bhushan, for a very, very painstaking, diligent and detailed discourse, chapter-wise, on Anand's book. And it is going to gladden the heart of not only Anand, but also his publisher, because after this, the sales of his book are going to skyrocket. I now invite Justice Sanjeev Khanna, Judge of the Supreme Court, to deliver his keynote and chairperson's address.
Respected Mr. Justice Ashok Bhushan, Mr. Justice Ramalingam Sudhakar, Mr. Raghav Chandra, distinguished guests, Namaskar and good morning. I am very happy to attend the launch of the book Defaulters Paradise Lost, authored by very talented Mr. Anand Marathia. When I received the book, I was struck by the subtitle, which talks about demystifying the insolvency and bankruptcy code. Having grown up in the 60s and 70s, I heard about mystery books, mystery novels, and sometimes criminal cases which were solved by the police. But in the last 3 decades, the term demystifying law has virtually become an accepted term. Demystifying laws connotes existence of a mystery. Are laws puzzles that need to be solved? The question is ironic. Laws are, in fact, meant to resolve disputes and not become disputed themselves. The second question is, who is to solve the legal mystery? Laws are not written and a product meant for legal experts. It is their inherent nature that laws concern everyone and are applicable to almost everything in our daily lives. Thus, they must never be a mystery to the ordinary people. This may be the ideal world, but it doesn't certainly apply when it comes to commercial and economic laws, for everyone accepts that they're complex and require interpretative skills. One of the reasons for this is that commercial laws are wide and cover several areas such as contract, sales, corporate governance, consumer protection, tax, banking, and finance. Therefore, it is difficult to create a comprehensive codification that adequately and accurately reflects all aspects subsumed in the commercial law. Further, these laws are constantly evolving with changes in business practices, developments, and technological developments. There is also need to correct anomalies and rebalance competing interests. I'll now pose the third question, as I find there's substantial number present over here. It consists of members of the bar and the bench. Do lawyers complicate laws? I had recently come across rules of professional conduct duly notified by a professional body in a Western nation. The rule provides, and many of us would agree, that advocates must fearlessly raise every issue, advance every argument, and ask every question. This is not the problem. The problem is when this professional zeal gets to a higher and exaggerated dimension, it leads to difficulties. Therefore, one can easily say that legal experts can contribute to effective and true implementation, or craft a mystery by employing interpretative skills and technical arguments that align with the interest of the side whose brief they hold. Lawyers, somebody has said, value complexity, ambiguity far more than simplicity. I do not agree. A true good lawyer makes everything simple. And that's what has been highlighted by Justice Bhushan in his address. There's another aspect to the laws which make it complex. Implementation and enforcement of laws, unfortunately, sometimes results in what I call is a cat and the mouse game, attempts to escape and capture. Consequently, the drafters are compelled to widen the scope and ambit of law so as to curb evasion and hoodwinking. This in turn has its own impact and repercussions on the adjudicators, including the judiciary, who at times have to interpret the law in a manner as to protect innocence and deal with unintended consequences and yet effectively enforce the law against the violators. This brings me to the second point of my address, which is what are the three general principles of a good law. The first is the laws must be practical. Laws are not just legalistic, but much more. Depends upon how practical they are. Unless they are practical and pragmatic, they become unworkable. The second aspect of good law is certainty. Certainty, according to me, is often linked with the language of the law, which should be plain and clear, and therefore ensures greater compliances. The third aspect of a good law, the principle of good law, is somewhat contradictory in nature. There should be continuity and consistency in implementation, yet at the same time, the laws must evolve to meet the demands of the society. They must mirror the society's dynamic nature adapting to changing circumstances and the challenges. Coming to the IBC in particular, there are two things which I have noticed which has contributed and to strengthening and the good results which we have seen in the IBC. The first is there was training of the stakeholders in the new law. Skill upgradation, awareness and understanding of the law was constantly gone into at different levels, including resolution professionals. I have learnt about the Insolvency and Bankruptcy Board of India holding workshops to train many of them. They call them train the trainer, which I can't understand because trainers, we all learning and we all being trained every day in and day out. The second aspect which I liked about it was the handbook which they had released in the form of a ready reference. These handbooks are very helpful when they are made by the regulator or the implementer himself, because it helps clarify a lot of small issues and questions, promotes self-sufficiency and minimizes reliance on legal experts. This is not something new. As a young counsel, I had the occasion to go through original site practice directions which were framed relating to the CPC and the CRPC, which were framed way back by the Lahore High Court. I still feel they are one of the best in the country in spite of the fact that laws over the time have changed and evolved. The third aspect which IBC has, with regard to the IBC, which is quite noticeable, apart from it being having a transformative impact, is the approach adopted by the legislature in crafting, recrafting, modeling and updating the laws. The spate of amendments which have taken place to rectify wherever there were flaws and iron out creases is something which is quite amazing. What has this resulted in? The results are here before us. Justice Sudhakar pointed out. I'm not going to repeat those results, but just highlight some of the figures which I was able to collate with regard to the cases dealt with by the BIFR. Between 1987 to 2000, there were about 3,068 cases, which means on an average 230 cases a year that were dealt with. The resolution plans which were approved and the companies which were revived was only 264, which means on an average 20 cases a year. These were worrisome signs, but it took a long time for everybody to realize what is happening. In comparison, IBC has rescued about 2,622 corporate debtors, out of which 720 is through resolution plans, 1,005 is through appeals, reviews and settlements, and 897 through withdrawals. Having said so, I'll be wrong if I don't refer to certain warning signs which have come. It's not been an easy, smooth ride, rather a roller coaster ride. Initial phase was one which was very responsive and showed very good results. For example, between October to December 2017, the financial traders under the resolution plans were able to realize almost 73% of their claims. The figure came down slightly between January to March 2018 to about 70%. But then there was a subsequent decline. Between July and September 2020, the figure was mere 20%. Of course, fortunately, unlike the DRT, the Debt Recovery Tribunal SARFAESI, which had these teething problems, which also had shown the same graphs, there are signs of recovery. For example, in 2023, for last 2 quarters, the claim is averaging about 30%. So this is a development we have to take into account. Where we have really failed in the earlier laws is the human resource. the human resource in the form of judges and the member of the bench, apart from physical infrastructure. As long as we keep a check on both of them, we should be able to achieve what we wanted to achieve by the IBC. In the end, is my hope, what I want to point out, the three areas which I feel which require some examination going into. The first area is with regard to pre-default stage, that is at the risk stage, the assessment and the remedies. I feel that AI may have a greater role to play as well as examination, fine assessment of distress signals for potential insolvency are concerned. There is also need for formulation of a pre-default debt recovery mechanism and debt restructuring options. This has to be gone into and developed on a big scale. The second is inclusion of special situation funds to deal with the bad debt problem. This is a little controversial, but I think in long term this is a solution, because SEBI has taken some first steps in this regard. Let's hope and see how does it develop. The third thing which I'm going to mention is directly related to corporate governance, level of probity and ethical work ethics. I like to see a time when law of personal guarantors in India is based on changes from the fairly conservative approach, which is adverse to taking risk in a market economy. My father was in service, my mother was in service. I cannot accept, even if my son or daughter goes into business, that I'll ever give a personal guarantee. It's just not acceptable. That's not true of me, but that is true of vast generation of persons from our generation. We are not born and brought up in that way. This personal guarantee, at least in some cases, results in denial of access to capital. Personal guarantees are appropriate in certain lending or contractual situations. They are generally not necessary or conducive to functioning of investments market. Instead, investment markets rely upon legal structures, regulatory oversight, and risk management practices. So, Mr. Chandra had talked about due diligence. This is something which just doesn't exist in India, whether it's at the banking and financial sector level or even in corporates. I sat on the company side. I've seen due diligence reports, including valuation reports, which were completely sham. They were just not dealing with the issues. It's for the younger generation now to catch on and get this opportunity. You have an opportunity on hand. The field is wide open, and it's a field which is waiting for change to take place. So grab that opportunity and do well. Thank you. Thank you so much for your attention.
Thank you, Justice Sanjeev Khanna, for a very, very illuminating and enlightening address on the subject of IBC and Anant's book. You've extremely well explained what is good law and how good law should mirror society and the challenges society faces. You've talked about the recognition of the excellent work done by the IBC through the IBC, the warning signals that one should look out for, the need to attend to the HR issues which are part of the larger process of judicial management of the pendency on these issues, and the larger issue of corporate governance. I think Anant is lucky that he has such a positive review from just about everybody, and truly your publishers should be expecting you to write another book after that. Anant, would you like to say a vote of thanks, please?
What do I say? I'm overwhelmed. Sometimes, as lawyers, it's not common for us to be speechless. But yeah, today I am with the praises and the blessings and the good words from the luminaries that are present over here. Definitely, I would only second the views that have been put forth by the honorable dignitaries that yes, India is moving in a different direction altogether now. It's not the same India. There was possibly an era pre liberalization, post liberalization till 2000, maybe 12, 13, where loans were granted, business grew, but the legal system was a little weaker and recoveries were a challenge. But that has been plugged in as well. And now, 2016 onwards, with the insolvency code coming in, I think that one challenge that we had is also taken care of. So we are, I think, almost ready, or rather we are ready to launch the next 10 15 years. If we are looking at organized systematic lending, business principles, business governance, corporate governance, and also I would say hopefully no more requirements of defaulters and their paradise. And if at all there is, I would not be too happy to write something called defaulters paradise regained, because I don't want them to regain the paradise. But let's see how this takes us in the next few years. Thank you so much to the dignitaries on the dais. Thank you so much. We'll have the panel discussion continuing after this as well.
Thank you, madam. Thank you, madam.
Mr. Arun Katpalia, Mr. Rana Mukherjee, Ms. Madhvi Guradia Diwan, Mr. Sumant Batra, may I please ask you all to request you to take your seats. Okay, okay. So, Mr. Batra, can I request you to kindly moderate this panel discussion? I think you'll be able to do justice to it, and yeah. Have we got everyone in the right place? Yeah. Oh. Mr. Katpalia is this one?
Yes, Mr. Kapadia. Then Mr. Mukherjee is walking now.
Okay.
Come back and join us.
So can I request Anand's team to request all those who've stepped out to come in? They can bring their cups of tea and all that. That's all right. They can bring that in. And Anant, you can please present, welcome all the panelists with flowers. I'm already done.
Thank you so much. Thank you.
So Sumant ji, now I'll request you to kindly, Mr. Sumant Batra. Happy to. Yeah, please.
Thank you.
Carry this.
Well, Anant reached out to me yesterday evening, said, Sumant, would you mind if I change your role to moderating? I said, with great pleasure, anything for a friend. And also, because then it gives me the liberty to ask the question that I want rather than what you pointers sent to me. So I sort of tweaked them a little, if you don't mind. I'm going to do it my way since you've given the mic to me. And I'll try to make it very, very quick because I know that we're running behind schedule a little bit. So keep it very sharp, focused, pointed. And I'm hoping that the responses would also be sharp, focused, pointed, and brief. So, the Honorable President, so may I request for your response on two things. And I'm actually was thinking when the distinguished guest was speaking in the earlier panel. One thing that occurred to me as something which fell from Honorable Justice Sanjeev Khanna was that the role of the lawyers in the whole dispute resolution. Traditionally, conceptually, we all know that the lawyers play a role irrespective without judging their clients' tasks, and they are just hired to do a role which they perform. But in insolvency, at least that is how my understanding has been, that it is essentially a non-adversarial process. You're not really supposed to be litigating on almost every aspect. Do you think, sir, that one of the reasons why IBC has become a bit more complex and what is contributing to the delays is that it has or is becoming adversarial? I mean, given the large number of applications that end up on your doorsteps every day, sir, what is your reaction to that, sir?
First of all, when you begin as a lawyer, not as a judge. So my exposure as a lawyer is to unravel a case and simplify that for the judge and get a result which is in your favor. I have not said this before, but many a times I have shared with my friends. When I became a judge in 2005, December, I realized that to my juniors I hardly had any case bundles to be handed over. And I did start thinking what happened. The case mostly was tax cases. It starts from, our friend was there, customs, central excise, income tax a little bit, FERA and things like that. By the end of the year, my case will be over before the Honorable Supreme Court and I would have given the bundle tied up to the client. But that is not the way the earlier legal system worked. There was a system called inheritance of a client. But inadvertently, I did not get into that groove. But then the satisfaction of a client getting a resolve is far, far happier than having bundles and bundles in your office. I enjoy that happiness. Now, having said that, every lawyer is not the same page. So, he has what you call the concept of litigating, appealing. There are lawyers who simplify the case. As all of you, many of you would know that I always like to have a chart prepared and simplify the case. This is how I was trained, and it did help in resolving hundreds of cases. But then, it is in the grain of a lawyer to argue every point that he thinks could appeal to the judge. And it is for the judge to decide patiently with a little bit of common sense and application of the law. It is happening in the code as well. But then, if you had just followed my speech earlier, it was the decision of the NCLAT on the basis of the argument by the wonderful legal luminaries here and across the bar, which gave the first ruling of the NCLT, clarified or overturned or modified by the NCLAT, and finally the imprimatur of the Supreme Court saying this is the law and this is how the code has to be understood. So it does help in evolving this law which has come in the year 2016. There's nothing wrong about lawyers putting their best foot forward in the way they want to think, and it is for the judicial authorities to decide it and give it a meaningful judgment. So it is symbiotic relationship, I wouldn't say adversarial, but timeline is something which is important and preparation is even more important. These are the two things which I expect out of the legal fraternity insofar as this code.
Thank you so much, sir. Arun, can I ask you a supplementary question on this? I mean, what I was really loud thinking was that I understand that we as lawyers have a certain duty to the client, and therefore we are supposed to, put the best foot forward, argue the best, and try to get the best results for the clients. But should there be, in terms of the advice back in office to the client, be a bit different in insolvency than another litigation in terms of trying to advise them this is best resolved outside the court rather than filing applications? It was actually from that perspective, how do we make it non-adversarial in terms of trying to prevent a litigation and find a resolution? Is of course where it becomes necessary, then of course one has to go. But that, do you think that's the approach one can have really in IBC, or it's no different from other litigations or dispute resolution?
I think IBC certainly is very different from other areas of law because the stake for the person who's in management is everything. So when it's a financial debt, in terms of evidence against him, it's completely stacked. So it's unlikely that he will get out of that mess unless he settles. And more often than not, they do not have the wherewithal to settle, which is why they're there in the first place, for whatever be the reasons. So settlement is certainly, in most cases, the only option and the only way out for a management which wants to remain in management. Failing that, one of the objectives of the code is to take away the asymmetry of information which really exists, and one of the reasons why the code came into being. And the management is seen as a part of the problem once the CIRP starts, because they're taken out of management, there's symmetry of information. And then the 12-way process starts, which is a far more costly mechanism for resolution. So pre-admission settlements are certainly easier. And I think the promoters are fairly conscious. They're very bright people, and they know what they can and can't do. So they really don't need that much advice, and they know why they are there and how they can get out of it. Sometimes then they resort to all other practices to try and obstruct processes and so on and so forth. But that's a part of, whenever you are faced with, it's an existential threat. So they will resort to whatever they can to try and save themselves.
I think what someone is going to say is a nudge from the bench. That's what you're looking at.
Well, sir, that too, I think it's a combination of a number of things, because what I'm really trying to get is how do we get to reduce the burden of the adjudicating authority, because we would always be faced with the challenge of delays, because that's an ongoing dynamic. You will resolve one thing, the other will pile up the cases. So how do you reduce the number of cases in the NCLT and reduce the burden of the NCLT is what I'm really trying to get to.
I differ with you, Suman, in this.
Yes, sir.
There was a time when there was a Chief Justice in Madras High Court. The registry, similar to what you said, he said, no, this number cannot be, this petition cannot be numbered, this is not maintainable, this is not admissible. So the registrar judicial was raising queries. I had the occasion to go and mention before the Chief Justice, who's now no more. So he called the registry and said, how dare you disallow a lawyer to file a petition? He said, put it under defect, bring it before me. It is for the judge to decide whether to admit or not. And that changed the entire scenario for cases and also my perception. I'll tell you why. Law is a part of the society. People should be allowed to come to court. They have to file petitions. There's in numbers, even thousands and millions. It is not against it. But if you remember Justice Sanjeev Khanna saying that the number of judges has to be increased in relation to the strength or population or the number of cases and the infrastructure. These are the two keys. We have to have a robust system where any number of petitions can be admitted, but it is for the judges themselves to control frivolous litigation, and we have to have two important factors. One is cost and the one is perjury. These two should be made it very, very fertile and workable, and the system will take its course.
No, I completely agree, sir, but I didn't really mean to suggest, access to justice is very fundamental in a rule of law society. So you can't really prevent people from going to the courts. That's not what I was really suggesting. What I was really saying was that how can we have an ecosystem where a lot of disputes get resolved without one having to come to the court, and thus saving the time and the cost of the court is what I was really trying to get, sir. So now I take your point that yes, we probably need to have a situation where if people choose to come to the court should be able to deal with it in an effective and efficient manner, and that infrastructure must exist, both soft and hard. I fully take that point, sir. May I then switch gears, sir, and ask you another question, and then I want to come to Madhavi on another point, which is a subset of this question itself. And I'm actually, my entire frame of questions is around how to make it more speedier for the resolution of cases. Do you think, sir, that alternate dispute resolution is one of the ways, other than, of course, your 2 pointers on dissuading frivolous litigation is cost, as well as you mentioned, that you have to come down heavily on people who are committing perjury. But outside of that, sir, do you think that a persuasive power of the court can be used to tell people to resolve it outside the court? Of course, you have systems where you have mediations and others, but that is something which has to be brought into the framework of the law as such. But even within the existing framework, to be able to resolve, to be able to use your influence as a persuasive power to tell the parties, why don't you sit outside and do it? And you remember, sir, in one of the very contentious litigations at Jill and Jal, you asked the parties to sit, and we were able to resolve, even it was about 45 crores of dispute, but the fact is that your persuasive power did help.
Exactly. I'll give you again, I'm sorry to go back to Chennai again. My senior, Mr. Habibullah Basha, once told me that there was a Chief Justice by name Virasamy, most erudite and a man of brevity. In the court, most of the judges, I think in Delhi also it will be the same in Supreme Court, after hearing the parties mostly in commercial litigations, there may be in issues on interest or rival claims. Even before an adjudication order is passed or a final in appeals and OSS, which usually is the issue, it appears that the judges have told, look here, we have heard the case. Now this is the terms of settlement. I'm looking at what you said. You will pay so much, this will be the waiver of interest, this is the balance interest paid. Take instructions 24 hours, come tomorrow. Both the senior lawyers seem to have agreed on almost 30 to 40% of cases that the judge has expressed, but now we can't do that. We can't express our view and then again go back and hear. But they have agreed and the cases got resolved just by one nudge from the bench, which of course you are saying, which I follow that principle where we tell the lawyer, look here, this is a case where this can be resolved by mediation. And now we also have the benefit of former judges and senior lawyers who take this cause and do mediation. I do agree. There has to be pre-mediation in almost all litigation, which is quite possible. And the government also is looking at it in a very, as we do in commercial litigation, in IBC also we can explore that. But the only factor which may have an impact in IBC is the stakeholders are a little large here. Because the earlier it is better, as Mr. Arun Katpalia said, earlier is always better in IBC cases. If it doesn't happen, it should always, the speed is the essence of court that has to also be maintained.
Well, thank you, sir. So I'll come back to you on one of your other favorite topics, sir, and artificial intelligence, because I believe that does also have a role to play. But I want to come to Madhavi, you first, and I'll give you my mic, don't worry, after I've asked my question. There are two other stakeholders which have a very important role to play in terms of how their decisions and function making impacts the efficiency of the whole process. Let me ask you about one of them, which is the insolvency professionals. You know, there would be many in the room as well, but we all do know that while some of them have done a brightest of the jobs, but the others probably have disappointed and not lived up to the expectations, if not disappointed. Do you think that that the insolvency professionals have met the expectations or the bar that one would expect them to stand by generally?
So yes, I'd say that insolvency professionals are certainly a very, very important and a vital pillar of this entire code. And just to give a little context, I think, you know, the fantastic thing that this code introduced was the fear in the mind of the promoter that, you know, time is now up. If you think you are going to remain in management and you can default without consequences, those days are gone. And, you know, of course, this was a far cry. It was meant to substitute and completely actually mark a breakaway from the Sikh Industrial Companies Act and that entire regime. Sarfezi also didn't help businesses to run. It was meant to mark a complete change of gear in a sense. And unfortunately, what is happening, and this is also linked sometimes, what I have noticed in a few cases, the role of the insolvency professionals. So the idea was that the moment you invoke the code, if it is admitted, you know, it should be resolved very quickly within the time frame, or you cut your losses and go into liquidation, sell your assets. Now, what is happening today is that, and I mean, this is relatively recent because I find that in the last 2 years, maybe, the IBBI has taken a spate of disciplinary actions against errant insolvency professionals. And, you know, there are a range of cases, but very interestingly, what I have noticed is For instance, an insolvency, a resolution professional engages a partnership where he is a partner himself for support services. In one of those cases, which is of course now pending before the High Court, I think 19 times the fees that the resolution professional himself was to earn was paid or to be paid to the support services. It had the imprimatur of the COC. But the question was that, what is your job if the lion's share is going to be taken away and we're talking of several crores of rupees, is going to be taken away by somebody else over there. So, and in some cases, what you will find very interestingly, what I notice is in liquidation. In more than one case, I have noticed the companies in liquidation for 4 and up to 5 years sometimes. And there are, large fees, which this is part of the disciplinary order. Of course, these are under challenge before the High Court. But the fact remains, the company is under liquidation for 4 and 5 years, 3 or 4 years in some cases. There is, huge fees which are being being paid to other professionals engaged by a liquidator who is an IP. So now, we are realizing that fear factor, that deterrent factor, which was there, say, 5 years ago, when the code, or 7 years ago when the code came in, that is losing a little bit of steam, because we find that the IP is the person who really has to coordinate this whole process, and it is based on his or her probity, efficiency, tightness, all of that is able to, will ensure success of either resolution or quick liquidation. You can't, this cannot go on forever, and it cannot become a bonanza for third parties, which is what, one is noticing. So I think that's a very serious thing, and I think it's important that the IBBI takes action and there is some deterrence over there. The disclosure is that I happen to be appearing in some cases, but I thought that the disciplinary orders, whether eventually, let us see whether they are upheld or not, but they make very interesting reading. It tells you a certain trend, because I've come across, I think, not less than 15 of those cases.
Yes, and you're so right, because the long-term implication of that, even mid-term implication of that, is just so horrendous for the entire profession, because in the short term it takes away the right of the celebration to those insolvency professionals who do well and have done some great job.
Yeah.
Their performance gets clouded. And secondly, it gives the right to the regulator to continue to tighten the regulatory noose on them. And then the entire profession has to then suffer from the entire increasing cost of regulation, which something, if the market performs on its own, can be bettered.
Yeah, well, one way of looking at it is that these are teething issues, and suddenly there is, let me say that even the legal community has, in a sense, we've been exposed to this whole very interesting new area of the law. We have gained from it, and but the idea is, there's a larger purpose in this. This was intended to cut away from a system where companies languished for 15 years in the SICA, in the BIFR, without consequences, and everything was, the assets were just eaten away before you had there was no resolution.
That's right. Got it. So Aruna, I want to come back to you in a moment. Just hold the mic for a minute. I have one question to ask Arun very quickly. I was talking about the other key stakeholder, Arun, which is the lenders, which have such a responsible, pivotal role to play in the entire process. They're the ones who actually sit behind the steering wheel, and even if not behind the steering wheel, they are actually driving in the back seat. Where do you think that this? Well, of course, we all understand that there's need to be a supremacy which needs to be recognized, the whole commercial wisdom. But do you think that there is need to be checks and balances in terms of how the lenders articulate their decision making and the accountability that needs to come with them, in order to make the whole process efficient and impactful? From a lender's point of view, that's a question that I had for you.
You can't exclude the lenders from the decision-making process. They are the most concerned. speed also for them is equally important. And perhaps, as Swiss Ribbon says, they're the best suited to take many decisions, which ordinarily the promoter and the management would, but given their absence, along with the professional, they are best suited to take. That said, notwithstanding their suitability, because they know finance, they know the sectors, they know the financial position of the company, and now they have access to information which earlier was not there. There's a conflict of interest. At the end of the day, they're concerned more with their recoveries than they are with the resolution. I mean, and that's a clear conflict that they have. But that I don't think one can really do away with, because they are the ones who ultimately have to take the decision. Certainly to do that, very often the processes are violated by them. And I don't think you can have processes straitjacketed, because surely if timelines can yield, you can violate timelines to yield better results, then surely the timelines must yield. But I think there are problems, systemic problems, where the brute majority of a COC is utilized to defeat inter se priorities amongst them. So somebody, a minority lender, has done prudent lending, has got a better security interest, but he's a minority, and very often the ones who have not done prudent lending, they will just use their brute majority to cram down a mechanism upon, and the Supreme Court seems to have applied that in the India Resurgence case, and perhaps that's been watered down a bit now, but that still is a problem and very often continuing to happen. And it's happening actually in a lot of matters which are ongoing, so ultimately that's one thing that will have to be addressed. We've seen in the case of Benani also, after the process is run, a new process starting. We've seen that. But these, it's a dynamic law, it's an economic process, so these things are inevitable. And at the end of the day, the problem is that the creditor who is running the process at one end is really concerned with the amounts that he is going to realize from whatever process is run. The other problem is, which happens is, also is reflective of their concern less with resolution than really with, and more with their own recovery, is resolution plans contemplate ongoing funding once the resolution happens. And one has found in several cases where after the resolution plan has been approved and the plan itself providing for funding by the assenting lenders, they have not come forward. And there are, in fact, there's a case which provides for 100% payment over a time period, and despite that, the plan is not being implemented because the lending hasn't happened, the financing hasn't happened. So these are issues that are constantly there, and the courts, that's why they are needed. But I just want to respond a little to that point that Madhavi had made. I don't think, there are large corporates where there's a huge amount of back-end work that takes place, for which the resolution professional does engage agencies. And the costs of that agency and the manpower that agency extends is hugely, vastly much more than what the insolvency professional fee would be. So merely because the agency's cost is 20 times that of the professional can't be a yardstick for determining whether there is or not some kind of wrongdoing happening. I agree with you, and the point is well taken that the professionals have to conduct themselves with probity and very often are found wanting. But the fact that there is a 20-time payment made or not made can't be a determining factor. But those are cases which the court, I suppose, will examine and decide.
Yeah, well, I think what Madhavi mentioned was
And
disproportionate.
Proportion has to be in the context.
Yes, of course, yes.
It can't be relative.
Yes.
It can't be because I'm earning X, somebody else is earning 20X, therefore it's disproportionate. If that person who's doing 20X is doing 20 times the work, it has to be. In the case of, pre-CIRP mediation, in the case of Section 7s and large Section 7s, That CRP mediation takes place in the form of CDRs, SDSs, settlement talks. So all of that is actually exhausted before they come to the, very often they come in a Section 7 and the CRP starts. Then certainly issues arise where mediation and there can be a proactive court, but inter se parties, there is that ongoing process has taken place. Nobody wants to come in here because they know they'll be taking a haircut.
Right. Yep.
Just one issue, just a thought process. All of you, we do understand that the code is to admit when there's a debt and default, if it's there, resolve and then take it. But at the time when the code was envisaged, did they factor in the number of IAs? But I'm only focusing on one issue. And I think Mr. Katpalia and Madhav Diwan will respond. Recently, we found a spate of IAs being filed as amongst COC members or persons who have been not admitted into the COC. They file IAs before us, and that litigation is a very serious, because it is the core of the COC, and they want their hands on to the Committee of Creditors. Now, is IBC meant to adjudicate the rival claims of FCs, and that takes a lot of our time. I'm not for a moment saying we are not going to adjudicate. Any case is welcome. But then, was it the intention of the code to resolve a dispute among COC also? Who should be added and who should not be there? Now, that is taking quite a lot of time of the NCLT. But that eats away our time for admission of cases, resolution of cases. This I want both of you to give your view on that.
Yeah. But sir, can I just go to Rana for a moment? He's been waiting for a while. Rana, I mean, I would request for your response on from the perspective of two stakeholders. One is the MSMEs, because they are the ones who probably find it very difficult to go to the rigors of a complex process, and sometimes it works as a deterrent for them and dissuades them from taking a plunge. And the others, the other stakeholders, the operational creditors, the trade creditors who feel very shortchanged in the whole process, outcomes of the IBC where the policy is that they stand behind in the queue and therefore nothing really reaches them by the time, the booty is being sort of, let's say, distributed. Now, what do you, I mean, from that perspective, would you like to share your expert view on this?
Yeah, first deal with the operational creditors problem. Yeah. You see, in the old SICA regime, if you recall, there was this concept of labeling someone as a pressing creditor, without whom the company could not survive and even keep going as a going concern. For example, the Dunlop case, where the nylon cord manufacturer was the sole supplier to the SIC company, and the BIFR decided that, their supply should come from, they should get a preferential treatment of payment while keeping it as a going concern. That concept seems to be missing here in the IBC. IBC, because when a resolution plan comes in, like Mr. Katpalia said, what happens to the post resolution plan funding? The operational creditors, who are actually the backbone of maybe that industry, fall by the wayside. First, their haircuts are almost like my head now, you have no hair. And then they are left by the wayside. Some of them may just be dependent on that company, but nothing is normally looked at in the resolution plan by the COC to say that they have a continuity in providing services or goods or whatever there is. So that is one thing which, of course, the IBC cannot factor in every possible, that's for the realm of the COC. As the COC has to take a call, but the COC, unfortunately, as Mr. Katpalia and Madhavi also said, comprise mostly of the financial creditors. So they are interested in how much they can get and they walk out. They don't want to fund that company anymore. It's for the resolution applicant to really come up with funds on their own. So that's one thing where the operational creditors, at times I think the IBC can segregate and keep this distinction in mind to say that, okay, you get a haircut, but you are also assured of a continuity of business insofar as the resolution applicant providing new services is concerned. That's one. Second, with regard to MSME, of course, 240A came in. The reason as to why 240 capital A came in was because Section 2 does not get in MSME as a defined body under the IBC. Now the legislators, they thought that, see, most of these MSMEs would be operational creditors. Because of the sinking of the principal corporate debtor, by a stroke of bad luck, that MSME will also fall by the wayside. And they would also go into insolvency. So they said that the old regime of 2015 under the old Act of the Industries Act, Small Scale Industries Act, they had a 2015 notification which spoke of some kind of resolution for those industries independent of the IBC. So this 2017 amendment was brought in to factor in that if such a MSME also goes down, then how do you resolve that problem? So they made that exemption of that section 29A, C and E, to say that they would be slightly separate from the other resolution applicants. Now, though they are falling sick, I had the fortune of arguing one case called Bafna Pharmaceuticals, where I had to really struggle hard to explain to the NCLAT that these are exceptional circumstances why 240A was brought in, notice in Swiss ribbons, and like the reverse CIRP, they should be given a first look at again promoting their own resolution plan with haircuts, and that should be at the pre-expression of interest stage. And that was accepted by the NCLAT, which is, judgments can be upturned at any point in time, but that I felt was the correct law for the moment that recognized 240A. Now we have this section 54A insertion of a pre-packaged insolvency, which is a very interesting section. So there, of course, the NCLT and NCLAT will have to deal with it. When this so-called MSME, they go down the drain for whatever reason, may not be always connected to a corporate debtor, independent of that. If the promoter can come up with a pre-packaged viable resolution plan, and there's a whole chapter on that, the NCLT would have to give it a serious thought, because these are not capital intensive industries. They don't have land too much, they have some machinery, and they are hard labor oriented industries. So this distinction which the IBC now is actually a really evolving act. We haven't seen an act like this earlier, where every second committee, based on the inputs from the NCLT and NCLAT, they keep working at making it more robust. And that's what is, I think, makes this stand out. One sentence which I think Justice Khanna said, complicate laws. See, lawyers don't complicate laws, we test laws. It is our duty to test a law. Otherwise, why should we have so many judgments which are being upturned on a pure concept of law, which when it goes up to some other bench, we have divergence of opinion. There are lawyers who seem to complicate by the way they present the case. But no, I don't think the intention is to complicate, it's to solve a problem for a client who is in front of the client. To give correct advice is one aspect which we have to follow, which most of us do. The clients may or may not take it, but we have litigious clients. So this testing of law is something which should be kept in mind. And I think the benches also would look at it. Sudhakar also said that everybody is open to come to court. So that's what makes this standout court.
Madhavi, you wanted to add a comment?
So first of all, I'll respond to what the learned chairman said. So I think, yes, I would agree that a lot of time is wasted in, taking applications, disputes between COC members or potential COC members to the NCLT. Now, I think a lot of this problem could be solved at the end of at the level of the RP. Because this is eventually his or her job to do. And of course, in defense of RPs, I will say this, that look, yes, there are times when there is some, uncertainty or some gray area, whether someone should be in the COC or should not be, or what share, etc. should be given, how the claim should be verified. There will always be those gray areas. And for instance, that happened before the home buyers amendment came in. There are some other issues issues which do arise, for which I would recommend that, you know, even the IBBI should take this up by having, you know, regular training courses on problems that are arising, that can potentially arise, and how RPs should be dealing with them. And I think that if this is done well and efficiently, I think it can cut a lot of time for the adjudicating authority. So I think that's one. So I think that also underlines how important the role of that RP is, because, you know, that even that time period which we have to maintain is really in his or her hands. To a great extent. Also, to respond to what Mr. Karpalia said, I would agree that yes, there are support services which are sometimes required, and they take, you know, they can cost a lot. But in the particular case that I was referring to, where 19 times the fees was charged, I'd just like to mention here that I had the opportunity of seeing that agreement, and it was very revealing, because the agreement which engaged those support services was a mirror image of section 18(1) of the code, which are actually the duties, the statutory duties of the RP. And all of those duties had been farmed out to a third party who was getting 19 times what the RP was going to get. That's point number one. Point number two is that, and in fact, the disclosure is that I think I'm appearing in that case, and I mean, we don't want to argue it out here, but this has been noticed in several cases, that when the company is in liquidation, and in liquidation, first of all, the idea is that it should be done swiftly. The idea is not that the company should turn into a milch cow for people other than the eventual stakeholders and people who are shareholders or creditors. That's one. What is happening is, because there's a cap on the fee of the liquidator himself, there's a cap under the regulations. What is happening, I've seen this in several cases, that the fees are being, because the liquidator himself cannot get more than a certain amount. There are support services, other professionals engaged where there is no arm's length distance between the two, and several crores are being paid out during the period of liquidation to those, so, you know, they're professionals, etc. Now, I ask myself that how complicated could this, I mean, I'm sure there are fees to be incurred and things to be paid out, but how complicated can this be that so many times because the liquidator's fee is fixed based on what he can recover for the company. But there's no cap on the support services. So they're getting several times and they're just crores being funneled out. So it is a serious problem, and we are going to go back. If we don't take this very seriously, we're going to go back to the SICA regime, where the company was moth-eaten, finished before anything was left for the stakeholders.
So I have only 10 minutes, Rana, so very quick comment, because
I understand there's also a success fee now being proposed. I don't know if it's notified. That I find it a very disturbing aspect if it comes about. The success, what happens if the company after 2 years says, no, the company...
Well, it's a globally acceptable
does the money go back?
now. Yeah, in one of the cases, the appellate tribunal appointed me as an amicus to assist, where I had, and the judgment was that the law doesn't really provide for a success fee. And in that case, it was a bit of a peculiar case where, I don't want to go into the details of that, but you know, the judgment is that success fee can't be charged, but the fact is there's a demand from the market, and they believe that might just be the way forward. So that's for the regulators to take a call. I just have one last question to ask, and then, you know, being a lawyer, I'm going to keep 5 minutes for myself at the end to be able to talk as well, and not just ask questions. So Honorable President. Well, yes, I know. So. Okay. So anyways, we certainly will do that. But so artificial intelligence, I know that this is one topic that you feel very strongly about, and I know that this is one futuristic area where we need to passionately invest in to be able to sort of achieve a number of outcomes. Of course, address the delays as one of them. So what do you think? And I know that you have been holding a lot of discussions with the ministry on this. So your comments.
See, this is a very hotly debated subject. To begin with, it was very encouraging, but with a limited framework, we have, with the help of our members, come to some sort of drawing board methodology in specified types of cases to deal with early resolution of matters in NCLT. I wouldn't say IBC, in NCLT in general, the use of artificial intelligence, but we have not put it effectively. But I would say because that is a little more complicated issue. If we start using AI in the manner which is being used across the world, then it may lead to some sort of comments from different quarters. But what we thought was, while we prepare the roadmap for doing that to speed up the process, we are thinking about what you call something which is a little bit a truncated version, of course with the use of machine learning or artificial intelligence, to provide that framework for resolutions of some certain issues of the NCLT cases. But the way forward is a lot more has to be done. And also I'm aware of one factor which has been highlighted by the government, the American government, where they say now they have taken it very seriously that be very careful when you're dealing with artificial intelligence. That has troubled me a little bit, saying that because we do not know, is this a fear of unknown or I don't know, because even they are in the process of learning something out of that artificial intelligence. So I'm a little careful about the approach, but nevertheless, the endeavor is to move forward on that line.
Thank you so much. Rani, you want to say something? No. You're done? Okay, very well. So, we have just about 5-7 minutes left, and I wanted to share my perspectives on this with your permission. Of course, a lot has been done in the last 7 years in IBC, and we will continue to. And I think it has been a game changer. We have seen a paradigm shift. We see how the tectonic plates under the way the commerce is done, the financial transactions are constructed are going to change significantly. I think that change in the mindset and the cultural shift is set as rolling. But of course, we are a vast country. It's going to take some time before we are able to see some very visible results. We can calculate in the form of impact assessment by IIMs and the others in terms of what the quantums of recoveries made. But what I think we need to achieve, and not beyond 10 years, less than 10 years, before 10 years, is to be able to look at what is it that we need to provide to an immensely young population that India is today, for them to be able to have a sound business environment. Average age of the population of India is 28 to 32, which is only growing younger, sir. We are today the youngest nation in the world in terms of the size of the population, the age of the population. The size, but the age of the population. And we are moving away from the time, and no government on this earth has the ability to provide job to that size of population. And therefore, we need to create a system where the young are job providers. They become job providers rather than job seekers, which means that they have to be the ones in a free market economy, as Justice Sanjeev Khanna said, be the wealth creators, not the government. Government doesn't have to create wealth for the citizens have to create for themselves, which means that the government's responsibility is to create a sound business environment where you can create wealth, you can create job, and that is what will take India into the next 20 years to be a developed country. And one of the most significant aspects of this, the mantra of that, what I believe is safe to fail environment. You have to start believing that it's safe to fail. You look at Chandrayaan 3, so the speeches that were made both by the current ISRO chief and the previous one, that they said their learnings on the success of Chandrayaan 3 came from the failure of Chandrayaan 2. And therefore, the learnings from the failure are the ones which will ultimately give you the strength and the ability and the vision to succeed and try again. And that is what we need to tell the youth of this country, that it is absolutely fine to take risks, absolutely fine to fail. Failure will not stigmatize you, will not isolate you, it will not punish you, it will not completely separate you from the society. You would still be given a chance, a fair chance, a second chance to try again. And that is what should be the policy making about, the regulation making about, is to create that sound, healthy environment where the young can take the risk to have their entrepreneurs, give wings to their dreams. That is how US was created as a free market economy. That is why today it is known as the country of dreamers, because the law, the system, everything gives shapes to your dreams. Dreams turn into ideas, ideas turn into innovation, innovation leads to intellectual property. And intellectual property is what Entrepreneurship is all about. And that is why US today has the largest number of intellectual properties created, whether it's the patents, whether it's the trademarks, or whether it is what technology that is created. And all that is because the concept of dignified exit and second chance. And of course, that is what our young need to get so as to be able to create wealth for themselves and for the societies and the communities that they're going to be living in. And IBC has a very, very important role to play, sir, and how we will actually take it forward also has a very important role to play.
Just one small request. Like we have timelines for setting a resolution plan in motion, can we also have a kind of timeline for filing of affidavits and cutting away with all this huge paperwork? Because everything is structured. There's a format in which Section 7 or 9 is filed. You don't need too many explanations from the other side to say, apart from if it's a clear-cut dispute, it hardly takes 10-20 minutes to understand whether the dispute is existing or not. Even if a timeline can be drawn when notices are issued, and there will be no further adjournments for filing of affidavits.
Yeah, Rana, you can take it up on the sides. I think that's a conversation that we can have with the president on the sides. Yeah. But there are lots of suggestions that come in. But if Anand, it's all right, can I close this session now, because we are already heading towards lunchtime. So Honorable President, can I thank you for staying back for this panel, to join us for this panel. Arun, to you, of course, Rana, Madhavi, and of course our silent panelists as well on that. Thank you so much. And of course, all of you for staying back to hear us. Thank you so much. Questions? Are there questions?
I don't think we'll have the time for it today. Maybe we can have it during lunch.
Ask on the sides.
Distinguished guests, ladies and gentlemen, as we come to the end of this event, I would like to extend my gratitude to the dignitaries for having graced the event, the panelists for an enriching discussion, the honorable members of the NCLAT and NCLT, senior counsels, lawyers, other distinguished guests for taking out the time and joining us today. I would like to thank our friends and family who've come down from Chennai and other parts of India, Singapore, and have supported us today. It really means a lot to me as the author and to my team. I would like to thank every single guest seated here and for supporting this event. I'd like to thank my wife for being my pillar of support in everything, and my father who's here to bless me for this event. I thank all my other family members who've come down to support this event. I would like to make a special mention to my team, which has been working tirelessly with me day and night to make this event happen. I thank Sri Raghav Chandra for all his guidance for this event, my publisher Thomson Reuters, and my event partner Bar and Bench for all their support. I thank every single viewer who's logged into YouTube and supporting us. I thank the officials of IIC. Before I thank God Almighty, with the permission of the Honorable President, if I can just speak a couple of lines in Hindi, sir, if I could. ये मैं अपने दिल से बोल रहा हूँ, ये फॉर्मल नहीं है. आज से 4 महीने पहले जब मैं पहली बार दिल्ली आया था, मैं सिर्फ 4 या 5 लोगों को जानता था. दिल में एक तमन्ना थी कि इस पुस्तक का विमोचन दिल्ली में किया जाए और लोगों का मुझे समर्थन मिले. आज मैं ये बात कह सकता हूँ आप लोग सबके सामने कि इन 4 महीनों में दिल्ली ने जो मुझे प्यार दिया है, जो मुझे अपनाया है, आज अगर मैं आप सबके सामने खड़ा हूँ, वो सिर्फ इसलिए कि दिल्ली वालों का दिल जितना बड़ा है, आज उन लोगों ने मुझे अपना बनाया और उनके समर्थन के चलते आज मैं यहाँ सब आपके सामने हूँ. मैं बहुत 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 आभारी हूँ आप सबका और तहे दिल से आप सबका शुक्रिया अदा करता हूँ इस समर्थन के लिए और इस प्यार के लिए, इस अपनेपन के लिए. थैंक यू सो मच, थैंक यू सो मच. Finally, I thank the God Almighty for being there and supporting us, and without whom nothing is possible. Thank you so much. I request all of you to please join us for lunch. Thank you so much. Thank you.
Just the right word. Where did you pick up from?